Ladies and gentlemen, please be upstanding for the arrival of His Excellency Rear Admiral Kevin Scarce, Governor of South Australia, and Mrs. Scarce, and remain standing for the playing of the Vice-Regal Salute. Thank you. Please be seated, and may we ask you to please switch off your phones. Unfortunately, our Chancellor, Dr. Ian Gould, is unable to be here tonight and sends his apologies, and it's therefore my honour to represent him. As a Council member of the University of South Australia, I'm pleased to commence the proceedings of the 2011 Annual Hawke Lecture, held under the auspices of the Bob Hawke Prime Ministerial Centre. And first, I'd like to call upon Uncle Louise O'Brien to officially welcome us on behalf of the Kaurna people.
Marawachanga, Kaurna Mira Nogwangani, Mani Nabudni Gani Atana, Naibiriko, Mankalakala Tandanya, Mianaku, Nature Yungandalia, Nature Yakanadalia, Padni Adlu Wadu. On behalf of the Kaurna people, I welcome you all to Kaurna country, and I do this ambassador of the Adelaide Plains people. My brothers, my sisters, let's walk together in harmony. There was a newly appointed elder up north, and his mob went to him and he said, "What's the coming winter going to be like?" And he thought for a moment, he said, "It's going to be cold. I want you to go and collect some wood." And so off they went. The truth be known, he didn't do the subject on the weather, but being a clever old bloke, he went down to the highway and rang the Weather Bureau. And he asked them, "What's the coming winter going to be like?" And they said, "Very cold." So he went back to his mob and said, "I want you to go and collect some more wood. The coming winter is going to be very cold." And so off they went. Then after another couple of days, he went down to the phone again and rang the Weather Bureau. "What's the coming winter going to be like?" And they said, "Very cold." So he went back to his mob and said, "I want you to collect every bit of wood you can see in sight. The winter's going to be very cold." So then after another couple of days, he went back again and rang the Weather Bureau and he said, "What's the coming winter going to be like?" And they said, "Very cold." He said, "What makes you so certain it's going to be very cold?" He said, "We've got satellites up north and the Aboriginal collecting wood like crazy. It's a sure sign."
On behalf of everyone here, thank you, Uncle Louise, for that very warm welcome. And now may I acknowledge His Excellency Rear Admiral Kevin Scarce, Governor of South Australia and Patron-in-Chief of the Hawke Centre, and Mrs. Scarce, the Honourable Bob Hawke, our Speaker, the Honourable Dame Silvia Cartwright, and Professor Peter Hoy, Vice-Chancellor of the University of South Australia. We also have with us tonight a very large number of special guests, not all of whom I can acknowledge in the time available. But I would, however, particularly like to acknowledge Mr. Hugh Van Lay, Lieutenant Governor of South Australia and Chairman of the South Australian Multicultural and Ethnic Affairs Commission, Mr. Tony Piccolo, Member for Light, representing the Premier, the Honourable Mike Rann, the Honourable Stephen Wade, Shadow Attorney General, representing the Leader of the Opposition, the Honourable Isabel Redmond, the Honourable Mark Carnell, MLC, and Senator-elect Penny Wright for the South Australian Greens, Mr. Stephen Marshall, Member for Norwood, the Honourable Robert Hill, Chancellor of the University of Adelaide, Mr. David Klingberg, former UniSA Chancellor, and Mrs. Maggie Klingberg, Dr. Denise Skiffington, Branch President, Amnesty International. And we have, too, a large number of representatives from the legal profession. And in particular, I'd like to acknowledge from the Supreme Court the Honourable Christopher Kourakis, the Honourable John Sulin, and former Supreme Court Justice, the Honourable Robin Layton. And finally, those responsible for this lecture, Professor Paul Ahluwalia, Pro-Vice-Chancellor of the Division of Education, Arts and Social Sciences at UniSA, and Miss Elizabeth Ho, Director of the Hawke Centre. Ladies and gentlemen, distinguished guests all, we're delighted to welcome you here. In 1997, the University of South Australia was moved to create the Bob Hawke Prime Ministerial Centre, recognising our first South Australian Prime Minister, the Honourable Bob Hawke. And tonight we're particularly delighted that, as usual, Bob is here with us to deliver the vote of thanks for this lecture. But this is also our chance to thank him for his support, not only towards our university, but also towards our state. He does much to promote the economy and well-being of South Australia, but tonight we especially recognise his commitment to excellence in education. We are deeply proud of our association with an Australian who has achieved so much, but also given so much on behalf of our nation. Engaging with the community is a major measure of our university's success, and we've been delighted by the contribution that the Hawke Centre has made to this effort. Its key message to the world at large is stated in these terms: think, connect, and act through the Hawke Centre. Behind these words are the gifts that the Hawke Centre brings to our state, our city, and our university, with expert and inspiring speakers and thinkers. And a number of long-term international relationships have been developed as a result, all enriching our solutions to larger problems. More and more people are accessing the ideas and solutions presented through the Centre, which in turn leads to a strengthening of our democracy, as well as significant guidance as to how we can all contribute to a successful future. I'd like to take this opportunity to thank our national patrons for their endorsement of the Centre, and to acknowledge how proud we are that we have Mr. Nelson Mandela as our international patron. For those of you who may not have attended previously the annual Hawke Lecture, it makes a national contribution to ideas for a sustainable world, and this one will be no exception. Tonight we consider the critical subject of international criminal trials, a promise fulfilled. As we witness the terrible aftermath of overseas conflicts from our position of relative safety, it's important that we understand both the growth and the limitations of global justice. And so, in the wake of a spate of world headlines on international injustice and the accusations of mass human destruction levelled against key players in contemporary theatres of war, we look to the vital insights that await us tonight from our distinguished speaker, Dame Silvia Cartwright. In particular, the question will be posed: is the reality matching the promise? We've shown all our past lecturers on screen tonight to remind you of the calibre of this lecture programme in honour of Bob Hawke. And we particularly ask you to recall that the sixth lecturer, the Honourable Gareth Evans, was a major contributor to restabilising Cambodia after the shocking genocide there. And he spoke to us on that occasion about waging war and making peace. And so here tonight, we have a continuum with the topic before us. We're particularly pleased to note this marvellous turnout for tonight's lecture, and many more await the publication of this lecture on the website and its future national broadcast on ABC Radio National and on the ABC Big Ideas website. The lecture publication is also sent to opinion leaders and policymakers across Australia. But now it's my pleasure to invite our Vice-Chancellor, Professor Peter Hoy, to introduce our eminent speaker, the Honourable Dame Silvia Cartwright.
Thank you, Paula, and thank you once again to all of you for coming to this special event. We really appreciate it. I have great pleasure in introducing Judge Silvia Cartwright. Dame Silvia Cartwright was born in Dunedin, and she graduated with an LLB from Otago University in 1967. After several years in private practice, she embarked on a judicial career that culminated in her appointment to the High Court, the first woman in New Zealand to achieve this. In 1987 and 1988, Dame Silvia chaired the Commission of Inquiry into the treatment of cervical cancer and other related matters at National Women's Hospital, the so-called Cartwright Inquiry, resulting in the uncovering of human rights abuses and subsequent major improvements. She was a member of the United Nations Committee monitoring compliance with the United Nations Convention to eliminate all forms of discrimination against women. She was made a Dame Commander of the Order of the British Empire in 1989 and Principal Companion of the New Zealand Order of Merit in 2001, and she received the Queen's Service Order in 2006. She was appointed Governor-General of New Zealand and served from 2001 to 2006. True to the pathway of her life, after that period of high office, Dame Silvia did not rest. She is well known for defending human rights, for furthering international justice, and for her deep analysis of the victim experience. So it was not surprising that she accepted a new role that reflected that commitment. She is currently one of 2 international trial judges in the 5-member trial chamber of the Extraordinary Chambers in the Courts of Cambodia, the ECCC, a court established by the Cambodian government and the United Nations to try those most responsible for the crimes that occurred in Cambodia. The ECCC trials deal with crimes committed between 1975 and 1989 by the Marxist group, the Khmer Rouge, under the leadership of the ruthless Pol Pot, a war experience that saw an estimated 1.7 million people or more die either by execution, overwork, disease, or starvation. Dame Silvia has described the purpose of international trials as to end impunity, promote peace and reconciliation, and punish those who have perpetrated proven mass crimes and achieve justice for the victims. In this address, Dame Silvia will consider the utility of international criminal trials against the backdrop of the Cambodian experience and others. I know we have our Foundation Dean of Law here and some of our law school students tonight, and I'm sure that they and students in other universities will particularly benefit from her wise reflection on the deeply complex matter of international law. I note also that this address comes at a time when international justice is prominent in our thinking. We are witnessing the results of the current mistreatment of citizens in the Middle East and the bringing to account of a ruthless figure in the Balkan conflict. These are terrifying chapters in our recent human history. The truth is that Dame Silvia and her colleagues face major challenges in delivering justice for such crimes, and we deeply appreciate her coming all the way from Cambodia to discuss those challenges. Dame Silvia, I have the greatest pleasure in inviting you to deliver the 14th Annual Hawke Lecture. Thank you for coming.
Thank you, Vice-Chancellor, for your kind introduction. May I first pay my respects to the Kaurna people, the traditional owners of this land on which we meet tonight. I also acknowledge His Excellency Governor Scarce, Patron-in-Chief of the Hawke Centre, Mr. Hawke, for whom this lecture is named, our Chair for this evening, Paula Nagel, and the Director and other staff of the Centre who have assisted me greatly in advance of this evening's lecture. It is indeed a privilege for me to deliver the 2011 Annual Hawke Lecture, arranged by the University of South Australia, host of the Bob Hawke Prime Ministerial Centre. Bob Hawke is a man who has made such a huge contribution, both in Australia and internationally, that even a New Zealander knows him and his work. His contribution goes beyond the political to his interest in and advocacy for issues affecting economics and human rights. In his own introduction to this centre, he spoke of these key precepts: understanding, compassion, and good policy. When he was president of the ACTU and as Prime Minister, he was a strong negotiator, and he used these skills to advance fair wages and gender equity. He also took the first steps towards reconciliation with Australia's Indigenous people, and he is known too for his efforts to assist the emigration of Soviet Jewish families and for encouraging 20,000 Chinese students to seek refuge in Australia after the events of Tiananmen Square. He is highly respected by Australians, and the naming of this lecture for him is one manifestation of that esteem. As you know, the title of my speech this evening is International Criminal Trials, a Promise Fulfilled, though there really should be a question mark after that. As you know, I am engaged as a trial judge in the extraordinary chambers in the courts of Cambodia, a title that reflects well the often unusual nature of the proceedings and subject matter. Known as the ECCC, the court has two parallel administrative processes, one international and one Cambodian, operates in the civil law system and has a trial bench comprising 3 Cambodian, 1 French, and 1 New Zealand judge. Based on the procedures used in domestic civil law courts, including those in Cambodia, it has introduced a comprehensive system of formal participation by victims at trial. The first trial concerning Gangek Yu, with the revolutionary name of Doik, the head of the notorious Tul Sleng or S21 security centre in Phnom Penh, has been completed, and the next, which charges 4 former political leaders in the government of Democratic Kampuchea, is about to begin. So it is necessary for me to emphasise that any facts that I will mention this evening are as yet unproved against anyone except in part against Doik. He has appealed that verdict given against him last year. The factual background is predictably tragic. Many of you will recall something of the period when Cambodia was ruled by the ruthless Khmer Rouge, a Marxist group led by a man called Pol Pot. It is estimated, as you have already heard, that at least 1.7 million people from a population of approximately 7 million died through execution, starvation, disease, or overwork in the 3 years, 8 months, and 20 days of the regime. According to scholars, Khmer Rouge ideology required that the country become self-sufficient. There was to be no conventional economy or formal education, no modern technology, and a reversal of the social order. Poor peasants were to become the elite, and new people or city dwellers, the educated, intellectuals, those who had studied or worked abroad, anyone who might oppose this theory were to be eliminated as actual or potential enemies. Ironically, the country was renamed Democratic Kampuchea. You may recall the news reports that after the Khmer Rouge gained control of the capital Phnom Penh in April 1975, approximately 2 million inhabitants were evacuated at gunpoint, and those who resisted were killed. Families were separated, the elderly, sick, and young perished immediately, and many starved or succumbed to illness en route to the rural areas. Once there, the survivors were put to work, tilling the fields, planting rice, building canals and dams, using hand tools, or dragging equipment usually drawn by buffaloes. Not surprisingly, as the regime consolidated its power, there was a terrible death rate. Although more than 30 years have passed since these events, even today the human cost remains palpable. The profile of the victims and some of their memories recounted at trial provides a vivid account of their suffering. At Duyk's trial, victims came primarily from poverty-stricken backgrounds, and their relatives and friends remain so today. But among them were members of the well-educated and comparatively wealthy diaspora, as well as the relations of the few Westerners caught up in the democratic Kampuchean regime. The trial chamber found that more than 12,200 people died at S21 from disease, torture, and murder. Most were killed at a site about 15 kilometres outside Phnom Penh, but some early victims, as well as the Westerners, were killed, sometimes burned or buried around S21 itself, a site that is in the middle of a modern, bustling city, Phnom Penh. S21 is now a museum displaying thousands of photos of the victims of all ages. One of the features of mass crimes is that they attract great interest in the international community. The Cambodian tragedy is no exception, and the events and the people have been examined exhaustively by hosts of scholars, historians, authors, social scientists, psychiatric, psychological, legal, and medical experts. When such studies are completed, they can be a valuable indication of the impact of atrocities on the victims, although I personally have doubts about the ethics of studying so comprehensively an already deeply traumatized community. One series of studies on the mental health of Khmer Rouge survivors and their descendants, conducted professionally several years before the trials started, and with appropriate support for the interviewees, provided useful information on their attitude to the ECCC trials. The great majority had heard of the ECCC and appreciated its work. A bare majority thought that the trials might promote reconciliation. Those who wanted to participate felt the court might provide justice, allow them to release their anger, allow for revenge, or provide a means of finding out the truth. Can a trial achieve these objectives? For reasons I will mention later, financial reparations will not be readily available to any survivor. Whether the trial otherwise delivers justice for individuals is not a question that I can answer. Justice is surely a subjective concept with a different meaning for every participant. A court's task is to conduct a trial of an accused that is fair and expeditious, that assesses the material put before it and reaches a determination of what evidence it considers the most reliable account of events. I also have personal doubts as to the benefit for suffering people to describe their experiences and loss in front of hundreds directly and thousands via television. Bringing a poor rural worker to the city to have him or her describe the anguish and impact of what are often deeply personal experiences is difficult at the best of times, and I do not feel qualified to assess the value to them of such public release of their emotions. As to revenge, both international and domestic law excludes revenge as a sentencing criterion. Punishment, deterrence, and/or rehabilitation are the only relevant factors. Modern sentencing practice accepts that revenge is uncivilized, but more importantly, is unproductive. The desire for revenge, however, is a normal human reaction, and that is one very good reason that the process of sentencing is in the hands of a neutral and informed tribunal. I would like to tell you a few of the personal stories of victims, because any lawyer or judge will tell you that the dry words of an indictment charging an accused with serious crimes come alive when the victim speaks in court. Judges, jury, and the public can assess for themselves the reliability and credibility of the victim account, and sometimes even the accused displays a glimmer of awareness of the impact of his offending. This was an important feature of Duyk's trial, as he publicly expressed his contrition on a number of occasions. More significantly for me, the victim testimony gave real vibrancy to the history of the regime and took us all back to the country it was in the 1970s under Pol Pot's leadership. Seeing and hearing the victims in person also demonstrates clearly that the survivors of the regime continue to suffer the consequences of the democratic Kampuchean regime. Apart from those living overseas, they are still unbelievably poor, suffer physical and mental illness, and live lives constrained severely by the fact that they received no education during the regime, other than the propaganda lessons of the Khmer Rouge leaders. Few, if anyone, listening today will have suffered the terror, deprivation, and indignities experienced by those imprisoned at S21, and the suffering of those who learn the fate of relations. So we remember what many victims are seeking, and so we remember the victims. I will share with you the words of some who testified at the trial of Duych. Net Pali's brother Bunti was detained and killed at S21. The last time Net Pali saw his brother, a soldier injured on the battlefield, was when he visited him secretly in hospital. After the fall of the regime, he looked for his brother for months, but when in 2004 he saw his biography in the S21 archives, he finally lost hope of ever finding him alive. He was deeply shocked that his brother, who had been totally loyal to the party and devoted his whole life to the revolution, was detained, tortured, and killed at S21. He had only one arm, and with his remaining arm he held up his brother's picture during the hearing and said, "I would like to show a photo of my brother. Here it is, like he is sitting close to me or next to me. I hope he is with me now and knowing that the accused is being tried. And I believe that my brother will be at peace, having learned that justice is achieved through this court. And may the dead soul of my brother who perished at S21 realize that and know that now justice is done for you. At the time you were taken to S21, you were blindfolded. And when you were taken out to be killed, you remained blindfolded. Now the court reveals the faces of those people who committed the atrocity. I can never find the dead body of you, and this is the only photo, the photo which really represents the ashes and the body of you." Chum Mai survived S21. He was beaten and tortured for 12 days and nights before being assigned to repair mechanical equipment. When S21 was evacuated, he was marched off, and by some miracle came across his wife, who had been imprisoned elsewhere. She had their baby with her, born while in prison. He was able to carry the baby for a short period, but soon after, while trying to flee the Khmer Rouge, they were shot at. His wife and baby died. He said this, "Whenever the word Tul Sleng or S21 prison comes to my mind, I cannot hold my tears. It drops automatically. Every single day when I hear about Tul Sleng, about torture, then my tears keep flowing. I was told because of the anger of the trauma I suffered during the Khmer Rouge regime that I need to keep my mind free from those feelings. However hard I try, my tears still drop." Bu Meng last saw his wife as she was being photographed at S21. He was shackled before being released to paint likenesses of Pol Pot. He still bears the scars of months of torture. He said, "I thought that if I could give my story to the chamber, that the ECCC would find justice for me. And I feel so happy, even if 100% of justice cannot be provided by the chamber, 50% or 60% will be fine, because I determined from the prison where I was detained that I had not committed any mistake or offence, and I just prayed to be survived." Van Nat was also assigned to paint or sculpt Pol Pot. He was captured and tortured before being taken to S21 to be held in a large cell shackled with others to a common iron bar. To this day, he does not know why he was arrested. He has painted many scenes from S21 observed by him or described to him by other detainees. He said, "I determined if one day I survived, I would compile the events to reflect on what happened so that the younger generation would know of our suffering. Those who came along with me to S21, the majority of them did not know of anything or any offence that could lead to their arrest. So I had to reveal, I had to write, I had to compile, and it can be served as a mirror to reflect to the younger generation of the lives of those who were accused with no reason, who committed no wrong, that were punished in that way." Nong Champal was only 8 when he was taken with his mother and his small 4-year-old brother to S21. He watched, terrified, as his mother was pushed, threatened, and photographed. After one night in a cell with some other women, 5 children, of whom he was the eldest, were taken to a place behind the kitchens. As she farewelled him, his mother told him to care for the children. One breastfeeding baby died in spite of him trying to feed it rice gruel. When the Vietnamese came, he hid himself and the surviving children in a pile of clothes, refusing to join the fleeing staff in case his mother couldn't find him. We now know that he was taken to S21 just days before it was evacuated, in the chaos escaping the inevitable killing that awaited all children. His mother died in those few days. While trying to find his mother, he saw what he thought was a nightmare: dead, bleeding bodies on iron beds around the prison complex. I will move now from the description of this particular tragedy to the overarching system of international justice developed over many decades in response to the need to provide greater accountability for those who commit mass crimes such as these. Since the Nuremberg trials, which with a distance of over 60 years have attracted a certain prominence, there have been many international instruments, such as the International Covenant of Civil and Political Rights, developed by the United Nations, to articulate universally accepted standards of justice to which states must adhere. These form the foundations for the law and practice which determine the jurisdiction of a number of international tribunals established to try those accused of mass crimes. There is now a solid body of international criminal law, including jurisprudence on genocide and crimes against humanity, which are the daily diet of these tribunals. The culmination of the drive to ensure that crimes which shock the conscience of the world are tried in a reputable international court came with the establishment in July 1998 of the International Criminal Court. It too has attracted much interest, with mainly lay people assuming that it can and will arrest and try the modern mass murderer. This lecture is too brief to explain why that is unlikely to happen, except in rare circumstances. Suffice it to say that not every member state of the United Nations supports the powers vested in the ICC. Not all member states have ratified the Rome Statute. And in cases involving these states, the ICC can proceed only following referral to the United Nations Security Council by a state party of a situation in which crimes within the court's jurisdiction appear to have been committed. The accused must then be arrested and brought to The Hague, where the ICC sits. Justice is never an even-handed, pure concept, unaffected by local or international politics or the practicalities of application. The extraordinary chambers were established as a hybrid court based in local law and procedure, applying international standards when required, and with judges, lawyers, and technical and financial assistance provided by donor countries of the United Nations. Although it has a majority of Cambodian judges in its chambers, a decision can become binding only if a supermajority of judges agree. Thus, during the Duik trial, on a few occasions, 4 of the 5 judges, in combinations of 3 Cambodian and 1 or other of the 2 international judges, determined varying legal issues. On one occasion, the judges split 3-2, thereby not achieving a supermajority. The practical consequence was that the legal issue of whether time limits for prosecution under the Cambodian law of crimes committed during the Democratic Kampuchea regime had expired or not was not pursued at trial. In the next trial, the trial chamber is to try accused who are aged from 79 to 85 for offences that occurred up to 35 years ago. Given the allegations that the many work sites and security prisons were located and purges occurred across the whole country, there are thousands, if not millions, of victims, direct and indirect. The legal and factual issues are very complex, causing some observers to remark that this will be the most difficult international criminal trial ever conducted. There are accusations of vast, forced population movements, enslavement, torture, deliberate widespread killing, forced marriages, spying on the citizenry, and a climate of terror and violence for the duration of the regime. The court's existence is tenuous with uncertain funding, unreliable political support, and occasional suggestions of political interference in its work. It was established after literally years of intense, frustrating negotiations between the royal government of Cambodia and the United Nations. It survives from week to week under the relentless scrutiny of international NGOs who publish widely their views and their advice. The mission is almost impossible: to try 4 frail, elderly accused, all of whom vehemently deny culpability, in a very poor developing country, with up to 4,000 victims wishing to participate at trial, and with judges and legal officers who read, write, and conduct the trial in at least 3 different languages. So, is it worth it? Let me measure my experience thus far against the gold standard for international criminal justice. And I quote, "Ubiquitous and multifaceted, there seems to be no limit to what international criminal tribunals are expected to achieve. In addition to the usual goals of criminal justice, they are tasked with achieving peace, telling a much contested truth, creating historical records for societies, and educating the world against the horrors of mass violence, to which I would add accommodating the needs of victims." I will begin by outlining the usual goals of criminal justice. These can be summarized as follows: to arrest suspects, ensure that they have counsel to advise and represent them, ensure a fair and expeditious trial, and on conviction, to impose a balanced sentence that takes into account punishment, reparation for the victim, deterrence, and rehabilitation. It is also to ensure that the trial is conducted in a calm and objective environment, and that the judge is independent and unbiased. This is part of a process designed to provide a civilized response to criminal offending and to prevent vigilante action. In principle, all those suspected of criminal conduct should be tried, not simply those who a government or international forum allows to be put on trial. The next factor is achievement of peace. As a judge in an international tribunal, my reaction is that it is difficult enough to fulfill the goals of a fair trial without having the added burden of achieving peace, which is often best placed in the political and diplomatic spheres. Peace might happen, but it is a byproduct of a fair and transparent trial. There are certainly occasions where the arrest and trial of a leader while the conflict is still raging enables peace talks to begin. But the practical difficulties of achieving this are many. First, usually he must be detained locally by domestic or international forces, or he might be arrested on an international warrant, an unlikely event given that few modern tyrants would go on holiday to the Costa Brava, leaving themselves open to such action. Equally, negotiations to end a serious conflict will sometimes result in promises that no legal consequences will follow. It is for the affected community to decide retrospectively whether allowing criminal acts to go untried has in fact delivered a better outcome. In the Cambodian situation, given that active fighting stopped about 15 years ago, peace usually means peace for the victims. The question then is whether, as part of telling a much contested truth, the ECCC is delivering peace to those who suffered because of the Khmer Rouge regime. In this context, peace is often coupled with reconciliation. There is always the hope that a fair trial, which allows evidence to be heard and assessed, will bring a certain peace to those who have long wondered why they were victimized and by whom. Humans have a great thirst for knowledge, and with that knowledge, understanding, even reconciliation and forgiveness may occur. Scholars who spoke at Duyk's trial commented on the prospect of national reconciliation. Richard Goldstone said, "What is important is a public acknowledgement from an official source, especially a court, that this is what happened to the victims. An admission of guilt and an acceptance of guilt is crucial to put a stop to fabricated denials that usually accompany all serious human rights violations." Another scholar, Raoul Jenner, said, "It is important to ensure that the Cambodian people know that justice has been done. Reconciliation is a process that must not leave justice by the wayside. Only when the Cambodian people had settled their past could they turn confidently towards their future." Part of the synopsis I spoke of earlier included the assessment of a much contested truth. My self-imposed question is, can a criminal trial provide a truthful account of what occurred during a regime such as Democratic Kampuchea? Numerous studies have demonstrated that the human memory is fallible. Memory can be affected by trauma and, of course, by the time lapse since the events occurred. 35 years after the events that unfolded under the Khmer Rouge, witness and victim accounts will usually be a truthful, albeit subjective, account of what they recall. But a wholly accurate account is never possible. Judges look for consistency in witness statements and between witnesses, and against other, perhaps contemporary records. In this way, judges conducting the trial against Duych were able to piece together from contemporary and current accounts a story that was credible, of arbitrary arrest, internment without trial, written confessions, often extracted under torture and therefore unreliable as to their truth, starvation, and shackling in unhygienic and cruel conditions, humiliation, terror, and finally, a brutal death in a field at night, their cries muffled so that others awaiting their fate would not hear and panic. Can a trial successfully create an historical record, which is another purpose of international criminal law? All contemporary international tribunals recognize the importance of protecting existing records of a regime under examination and creating and preserving trial records of testimony that ensue during trial. This forms part of the record for scholars, but more importantly for those who have suffered and for those who will in later generations wonder about their history of their country. Archiving of material is usually taken very seriously by international criminal trial administrators, although, providing the will is there and the finance available, an archive of existing material could equally well be achieved without a criminal trial. And can an international criminal trial educate the public? Every international criminal trial since Nuremberg has shared the broad goal of educating the world against the horrors of mass violence. It is questionable whether the objective summarised in the phrase "never again" will ever be achieved, and I do not expect the international community to be any more persuaded to forswear mass violence after hearing the account of the Khmer Rouge trials. What may have been advanced, however, is the knowledge of the Cambodian people. Until recently, the policy, politics, and events that occurred during the democratic Kampuchean regime had not been taught as part of the Cambodian school curriculum. It is therefore of note that more than 30,000 members of the public from villages, schools, universities, non-governmental organisations, representing interested governments attended part of Duyk's trial. Many more followed the trial on television or radio, indicating a high degree of local interest. This, in my view, is the result of two factors: the almost complete absence of public knowledge of democratic Kampuchea policy and who drove it. Simple questions like why, by whom, what happened to my relations have never been answered. During the regime, secrecy was strictly, even brutally enforced, as the leaders ensured that all enemies, real or perceived, were swept away, a euphemism for arbitrary arrest, detention without trial, torture, and killing. In order to ensure total secrecy and to induce maximum compliance with the regime, if, for example, a factory manager was arrested on suspicion of spying, he and his family would be killed, and all his workers either sent for re-education or killed themselves. Consequently, the vast proportion of the population knew little about why they were expected to work and live in prison-like conditions and why so many disappeared. The trial gave an opportunity to hear and see for themselves something of what had occurred. The second factor relates to the siting of the court in the countryside outside Phnom Penh. For all the problems of alleged undue political interest and difficulty of local access, there can be no other court that has experienced so much public participation. Although seasoned judges at the Duik trial expected the initial intense interest to last for only a few days, in fact, most days the more than 500 seats were full, and on occasion those left outside watched on live video streaming from an open-air cafe. Village chiefs and NGOs arranged transport to the court, leaving at dawn from their rural areas, and villagers poured into the courtroom, watching from behind soundproof glass and, by all accounts, commenting freely on their views of the witnesses and the accused. In the towns and villages across Cambodia, people in their thousands also watched on television or outdoor screens. Turning again to the victims and their needs. I have spoken about the profile and experiences of some of the victims of the Khmer Rouge, so it may be of interest to understand a little of the procedures that apply to victims during the trials currently underway in Cambodia, and then I will make some concluding remarks. As part of the civil law process that applies at the Khmer Rouge trials, the victims have the right to be joined as parties and to participate at trial. Their role is to support the prosecution and to satisfy the court that as a direct consequence of at least one of the crimes alleged against an accused, the victim has suffered physical, material, or psychological injury, upon which a claim for collective or moral reparation might be based. In this capacity, they are entitled to legal representation, and may describe their injuries and experiences to the court. In Duyk's case, there were only a handful of survivors of the security centre administered by him, and during his trial, some of whom I have quoted earlier spoke of their terrible experiences. In addition, a number of those who had been indirectly affected, usually because of the death of a close relation, also told the court of their suffering. The process for participation and the seeking of reparation was, to my mind, most unsatisfactory. First, the 90 civil parties represented only a fraction of those victimised as a result of the more than 12,000 tortured and killed at S21. Other survivors are too traumatised, poor, or otherwise unable to participate, in spite of the best efforts of the local and international communities to help and support them. Moreover, the word victim has always been associated with those who were not directly involved with the regime. During the Khmer Rouge era, young peasants aged about 15 were deliberately selected to work for the regime. Many were illiterate, and most, if not all, became so inured to the climate of terror and violence that their lives and the lives of their families changed forever. Some were themselves put to death for disciplinary infractions, such as falling asleep on guard. In these circumstances, the words victim and perpetrator become blurred. The issue of reparation was also problematic. In most domestic criminal trials where reparation is ordered, it takes some monetary form and is ordered against the convicted person. For the trial chamber, this was not possible, as Duych was penniless, and the royal government of Cambodia has no fund for the provision of financial compensation. So after working through a complex, time-consuming and traumatic process, often sitting for hour after hour in court, listening to what might have happened to their parents, husband, brother or sister, the victims found that the trial chamber had no jurisdiction to order anything except formal recognition in the judgment. The compilation of all Duyck's statements of apology and acknowledgement of responsibility was also ordered to be published when the judgment becomes final. Given the very large numbers of victims seeking admission as civil parties at the second trial, and acknowledging that improvements are required to ensure that the victims receive better recognition of their suffering, a new regime has been incorporated into the ECCC rules. Individual victims will now form part of a consolidated group at trial stage. They will be represented in court by lead co-lawyers, while the remaining individual civil party lawyers will continue to advise and assist their clients, but will have no automatic right of audience before the court. An important reason for amending the system was also to ensure that the trial is both fair and expeditious. Between 2,000 and 4,000 civil parties, represented by more than 30 lawyers, may give the appearance of unfairness when opposing a small number of accused, and is in any event clearly unmanageable. Modifications to enable proposals for mostly symbolic reparations in the form of stupas and other memorials have also been made. If ordered, these will very likely be funded by foreign donors. Let me conclude in this way. Although every country that has suffered egregious crimes against its people has a different story to tell, the cumulative facts of the cruelty and apparent indifference of those who order, assist, or allow such tragedies to play out render us speechless. In the last few decades, the world has been shocked and shamed by similar events in China, the former Soviet Union, the countries of the former Yugoslavia, Rwanda, and other African states. And as I wrote this speech, conflicts were still raging, and still do, in many other parts of the world, as citizens call for changes in their governments. Until these battles end, we do not know, but history allows us to assume that many criminal acts will have been perpetrated on innocent people by those who wish to gain or retain power at all costs. What is of note is the widely varying contemporary approach taken to the delivery of justice. Events in Egypt, Libya, Pakistan, Serbia have furnished us with a wide range of examples, from the killing of a suspect to the peaceful arrest and transfer to a national court for extradition hearings in another. In Egypt, it seems likely that domestic courts will try the former head of state, while in Libya, an end to a bloody conflict might occur after successful negotiations for a pardon and amnesty are negotiated. Each of these examples give us an opportunity to reflect on what justice means and how it is best delivered. By instant retribution, by negotiating at least a ceasefire, if not final peace, by coming to an arrangement with the main perpetrators, or by means of the more banal path of arrest, trial, either in a local court or an international one, at which the allegations may be tested and the victims have an opportunity to speak. What is also remarkable is that the trials, whether domestic or international, have become more regular, and as a consequence, impunity has been diluted. As Serbian President Boris Tadic said when Ratko Mladic was arrested recently, all war criminals must face justice. Compared with a few decades ago, the strong man now runs the risk of the humiliation of a trial, which will reveal his all too obvious flaws and his egotism or greed. International criminal justice is now a reality of modern legal systems. Its usual aims are to try those most responsible for notorious mass crimes, but it is often hobbled by political negotiations domestically and internationally, inadequate funding, and the absence of other resources needed to complete trials within a reasonable period following the criminal offending. It cannot hope to offer an end to impunity for the commission of mass crimes, but what it can do is demonstrate to those who have suffered that prosecution may occur, some form of justice may result, and that the world has listened, however imperfectly, to the voices of the victims. In Cambodia, the trials being conducted before the ECCC will be of only a fraction of the senior democratic leaders or those most responsible for the carnage that occurred during the regime. Others will never be brought to trial. Death has intervened, or financial or political considerations will make it difficult for an international tribunal based in the Cambodian courts to arrest and to try other suspects. The system is indeed flawed, but it is better than the historic indifference to crimes, which has for generations, as in Cambodia, affected the health and education of the ordinary people, cast them into poverty, and left them in a state of endless grief. Tēnā koutou, tēnā koutou, tēnā koutou katoa.
Dame Silvia, thank you. It's now my great pleasure to call upon the Honourable Bob Hawke to give the formal vote of thanks to Dame Silvia.
Your Excellency, Kevin Scarce and Mrs Scarce, Dame Silvia Cartwright, Paula Nagel, Vice-Chancellor Peter Hoy and other representatives from the University of South Australia, all other distinguished guests here, and I can't name you all, ladies and gentlemen. And to you, Peter, thank you for the, Uncle Peter, thank you for the, Uncle Louise, thank you very much for the welcome to country. Dame Silvia, I want to thank you most sincerely for the marvellous contribution that you have made this evening, which adds yet another great chapter in the distinguished line of orations in the annual Hawke lecture series. We are indebted. But before I go on to thank you in more detail, I know you'll appreciate if I first of all say another thank you, and that's to the mob. Thank you very much for being here once again. You turn up every year, you give great support to us, and we thank you very sincerely for your continued involvement with the work that we are trying to do. Dame Silvia, you have this evening further enhanced this event, and you can see, I think, that it has become an integrally important part of the civic life of South Australia, and your contribution this evening has further served to cement that position. I want to thank you, Dame Silvia, for the compassionate yet astringently analytical approach that you have brought to help our understanding of the complexities involved in the prosecution of those responsible for crimes against humanity, and the way in which you have analysed historically the way in which, albeit somewhat gradually, we are moving forward in that area. It is, of course, as you appreciate, very important for us in Australia, and in a sense, me personally, to hear about Cambodia, because you'll recall that we in government took the initiative in bringing about the peace in Cambodia. Our American friends weren't very happy at the time, you remember, because it involved talking with the Vietnamese government. They didn't like that very much, but we didn't always do what the Americans wanted us to do. And we, of course, were right on that, and indicative of the measure of what was achieved was the fact that Gareth was being talked about, nominated for the Nobel Peace Prize for the work that was done there. So you'll appreciate that for us, Cambodia is a matter of very, very important significance. No one can go to Cambodia without being struck immediately by the impact of that period. You gave the statistics, Dame Silvia, of 1.7 million, but you go there and you can hardly meet a person who did not have a relative or a friend who was either murdered or tortured or in other ways suffered during the horrific period of that regime. When you listen to what Dame Silvia has to say, there's one basic conclusion you come to, is that we human beings are a strange mob. We are capable of great compassion and decency, concern for our fellow human beings. But human beings are also capable of indescribable evil. And Dame Silvia, what was so important in listening to you is, in terms of the Hawke Centre and what we're about, is you give such a broad dimension to the sort of things that we are concerned with. We at the Hawke Centre, Prime Minister's Centre, and all the research that's being done there and the public work that we do, what we are essentially about is trying to make people understand the capacities of human beings to create a better life for themselves, for their children, for their fellow citizens, not only within South Australia and Australia, but in making a contribution to a better world. And we are helped in our thinking and our work when we have such a dispassionate yet deeply analytical analysis of just how evil mankind can be and how we are gradually over time, as Dame Silvia pointed out, improving our approach in these matters. It is true, more true now than it was a decade or so ago. It is more true now, as Dame Silvia says, that the international community is accepting the responsibility to create an apprehension in the minds of those who would commit these heinous crimes against humanity, to create the awareness and the understanding that the international community is not going to be prepared to stand idly by, as it has too often in the past, and allow these things to happen. And we are so deeply indebted to you and people like you for the work that you are doing to enhance that understanding in the minds of those who would do evil, that justice can come. So I hope you understand, Dame Silvia, that it's not just the interest we have intrinsically in what you've talked about, but to see and understand that what you have been talking about is part of the broad thinking of our people here in the University of South Australia generally, and in the Hawke Centre in particular, that what we are about is looking at all things, all issues which can make for a better understanding between people, can bring about a better sense of commitment of citizens to their responsibility to act decently, constructively towards one another here in our smaller community, in our nation and in the broader world. And we thank you again, Dame Silvia, most sincerely, as I say, I repeat, not just for the fascinating and informative information that you have transmitted to us this evening, but, as I say, for the part you've played in broadening the understanding of our people here about our responsibilities as citizens in this world. Ladies and gentlemen, would you please join me in again rising and thanking our guest speaker, Dame Silvia Cartwright.
Before bringing tonight's proceedings to an end, I'd like to repeat that a full transcript of this lecture will be placed on the University's Hawke Centre website and will be broadcast at a later date on ABC Radio National, as well as locally on Radio Adelaide. Thank you all again very much for coming. Please now be upstanding for the departure of His Excellency, the Governor of South Australia and Mrs. Scarce.